Ladies and gentlemen, a very good afternoon and welcome back.
High Court of Karnataka in the year 2014 at the age of 38. He is also the Additional Advocate General for the state of Karnataka. Dhyan has extensive experience in constitutional law, civil and commercial litigation and arbitration. He has acted for various multinational companies and large conglomerates in litigation initiated in India and in arbitration within and outside India. He is engaged as lead counsel in various fora including the Supreme Court, state courts, district courts and various tribunals across the country. With this brief introduction, we welcome you to the session, sir.
Many chartered accountants, except possibly at the National Company Law Tribunal, in one place. And of course, I must say, on a lighter vein, that many lawyers complain that chartered accountants are slowly taking over their profession as well, with inroads being made in various tribunals slowly. But chartered accountants, I think, have a very significant role that they play. And they play this very significant role not just because they have a great business side understanding of a client's requirements, but also now by virtue of the fact that they can appear and represent clients in various tribunals. And all of a sudden you have the National Company Law Tribunal where chartered accountants not merely represent various parties, but also act as counsel for them and also become ultimately resolution professionals. And I think there can't be anyone else who can carry out this role as effectively as you do. But I really consider this a great privilege to be invited by the Karnataka State Chartered Accountants Association. And when Mr. Pramod Shri called me and said that he wanted me to speak at this conference, I was wondering what I could possibly say to such a galaxy of experts in your field. And he said, well, we want you to speak on arbitration and mediation. And I said, oh, yes, that may be an area where I can speak about, because I can tell you with some amount of confidence, that's possibly the only area where I don't see too many chartered accountants actually involved in the entire process itself. And that is something which I think you've left for us lawyers still. So lawyers are carrying on this part of the profession quite effectively, but I don't see why chartered accountants can't be involved in this. Now, if you look at why arbitration, I possibly not many of you have actually been involved in the arbitration process, or possibly in mediation, although I know that chartered accountants regularly settle disputes for their clients on and on. But what I want to actually speak to you about, I'll take a little time to go into what arbitration is, what mediation is, before I come into the question of how chartered accountants can actually form and play an extremely important part in arbitrations and in mediation. Pendency in India in courts today is 4.7 crore cases, out of which about 80% are in the lower courts, that is the civil courts in India, and the balance in the high court. Civil courts meaning therefore you have about 4 crore cases in various courts throughout the country. Therefore, all of a sudden, the legislature realized that you can't continue having courts deciding all cases. You need to find avenues which are outside court to resolve disputes. Well, arbitration is not new in India. In 1799, the first Bengal regulation brought about arbitration. Then in 1899, the Arbitration Act came into existence. And then in 1940 came the Indian Arbitration Act, which continued till 1996. Now in 1996, there was a huge shift. The shift was the fact that all of a sudden, you brought about an Arbitration and Conciliation Act, bringing two most important aspects in one law. Arbitration on the one hand, and conciliation, which you commonly understand as mediation, into the other. Therefore, you had a law which actually projected and wanted parties to try and find a way to resolve disputes, not merely through a dispute resolution process, but also by mediation, so as to bring an end to disputes. Now, how does arbitrations work? Arbitrations, I'm sure a lot of you may have gone to courts. So you have seen the pendency in courts. You have seen as to how lawyers in large numbers are found in courts with one judge and a lot of cases every particular day. The advantage of arbitration is the fact that you have one case, and that is your case, before a set of people or a person who acts as an arbitrator and whose entire time is spent only in deciding your case. So the idea was you have that one person whom parties choose to decide a dispute definitively, which means that the decision once given should become a decision that is enforceable like a court decision. Therefore, they said, now you take it out of the court. We'll put it outside. We will appoint a person who the parties agree. And once the parties agree on that particular person, he will decide their disputes. Once he decides, you give finality to it, so that it puts an end to the dispute between the parties. That was the plan. It's a different matter that the plan didn't work as well, because then courts, of course, can never cease interference in that process, and therefore started courts interfering in awards. But ultimately the objective was that you have one person or a group of people, let's say 3 people, who will decide a dispute definitively and finally between the parties. That was the plan. We've seen a lot of change in the law, of course, and we've seen so many significant changes. And the fact remains that today, the value of arbitrations has gone up tremendously. When I started practice, a 1 crore arbitration was very large. Today, even a 1,000 crore arbitration is not very large. And therefore, the involvement of different professionals at different points in time in the arbitration assumes great amount of significance. Well, you see, a case which would take about 15 years in court is now over in 3 years before an arbitrator. And still people, of course, complain that there is significant delay. But the fact is, you are now reduced time from 15 years to 3 years in an arbitration setup where party-chosen persons decide a dispute. Now, interestingly, what you will notice is, and I can say this with a fair amount of certainty, I have appeared before a large number of engineers as arbitrators. I've appeared before a large number of judges as arbitrators. I've appeared before a large number of lawyers as arbitrators. But I've never appeared before a chartered accountant as an arbitrator, nor have I ever sat with a chartered accountant as a co-arbitrator. Now, this actually creates a huge vacuum. And this vacuum, I have always wondered why it is never resolved. Because the importance of a chartered accountant as a member of a tribunal can never be disputed or denied. And I'll tell you why I'm saying this. We are not talking of regular land disputes. I mean, there are land disputes, there's a rental dispute, there is a dispute with the landlord, there is a dispute with relating to purchase of a property. We are not talking of those disputes. Those disputes are not for chartered accountants to really decide. I'm talking of valuation disputes. Let's take a dissolution of a firm, a partnership firm. Dissolution actually is possibly, especially for partnership firms, is the most complex of disputes, because you need to value different parts of the business in order to distribute it amongst the partners or to make payment to partners. Now, what, I ask myself, can lawyers or judges really do? And what do we really need there? What we really need there is the presence of a person who understands as to how a business is valued. Of course, as lawyers, as judges, as arbitrators, you will listen to arguments and then make a decision. But where the presence of a chartered accountant, let's say a panel of 3 arbitrators, and there's one chartered accountant, one lawyer, and one judge who form the panel of determining a question of valuation of a simple thing like like a firm of which runs a business, let us say in Bangalore, which has to be dissolved and the assets distributed, liabilities paid off, and the business closed. This can only be done with the presence of a chartered accountant. But I find that I have never seen till today any arbitral tribunal with a chartered accountant as one of its members. Of course, there is, I can understand a significant amount of hesitation by chartered accountants to actually get into this, but I wonder as to how engineers do huge construction disputes worth thousands of crores and decide all those disputes, and ultimately you realize it's not all engineering practices. It is essentially also law, also contract. And I can't think of anyone who's possibly had a greater amount of knowledge of, let's say, partnership law or mercantile law or sale of goods that chartered accountants have. And that is where you have, I don't know how, but artificially created a vacuum of not having chartered accountants to decide those disputes. Now, of course, one may say that, well, that is the arbitration or the arbitrator point of view. Let me give you another example, actually. There was once a situation which we had where there had to be a sale of certain shares of a company in exercise of what is known as a put option. I don't know if all of you are aware of the put option in shareholders' agreements, where you have a put option where you put and sell, or you call and buy, or you have a drag along right where you drag along the shares of a minority shareholder and sell it to a third party, and there disputes arise. When disputes arise, it is always on a question of valuation. It is never on a question of whether you are entitled to do it or not. That is a smaller issue. You read the contract, you'll know as to whether you must do it or not. So this issue arose with respect to a contract which was relating to an Indian company, but involved a foreign shareholder who was in Belgium. Arbitration was held in London. Lawyers were from England, and we were also lawyers from India assisting because it was an Indian law arbitration. There was a put option in that contract which they were seeking to exercise. Now, after 10 years, as all of you know, contracts are written today and then forgotten the next day. They are looked at only at the time when there's a dispute which starts between the parties. So suddenly everyone said, let's look at what is this put option, and started reading. And then they realized no one can understand this put option. And nobody could actually understand as to how to give effect to the put option. Interestingly, what happened was there was this very senior partner of a London law firm who had drafted the contract when he was younger. He said, well, this put option was actually, we consulted a chartered accountant. And it was a chartered accountant who put in place this put option. I think we should go back to him. So they all went back to him and asked him. He then said, yeah, it's very simple. And he put down a clear formula as to how it works. And only after the formula was put down did all the lawyers understand that, oh, this is what this clause meant. So, there is one classic example of how lawyers sometimes miss the most evident of facts and require someone who understands this in terms of valuation far better to actually come forward to do it. Now, if such a person is on the panel of arbitrators to decide this, it makes the job of everyone else simpler. It makes the job of the other panelists who are on the panel also simple. It also makes the job of the lawyers simple. But you will find significantly a complete lack of arbitrators who are chartered accountants. Well, that's of course the final step, but to get to that final step you need to actually do more arbitrations. But do more arbitrations does not always mean that you do arbitrations as counsels or as lawyers who argue cases. Chartered accountants actually have such a significant breadth of scope of work in an arbitration. Let's take simple things like valuation is one thing, of course. Determination of things like loss of profit. Determination of questions of quantification of a claim. Determination of overheads in a construction contract when a claim is made. Lawyers are ill-equipped to do it because we don't understand finances the same way as you do, which is why we need chartered accountants to do it. Now, how do chartered accountants do it? I'll tell you the good side and the bad side, but first the bad side. The bad side is, if you ask a chartered accountant to give a valuation or give a particular determination of what is overheads, the chartered accountant will sign off on what the client has said. And this is a common experience that many of us see in arbitrations. A chartered accountant would sign off on what the client thinks is the most relevant amount to be quoted as a claim. Now, that is the danger. The danger is it becomes easy to knock off that claim as being a wrong claim. Which is why you have to shift from being someone who is close to the client to becoming a little independent of the client. But I can tell you without any doubt in my mind, that is possibly the greatest area of practice for a chartered accountant. To get into this valuation and determination of costs, profit, overheads, and to provide an absolutely technically sound report which cannot be impeached is something which all of you are capable of, but you seldom find that actually being done. Unless the chartered accountant is told that you have to act as an expert independent of the parties, which also happens. Therefore, you have in large construction disputes, in large disputes involving valuations, you will have two sets of experts. One expert for the claimant, that's the person who's making the claim, another set for the respondent who is responding to it. And you will find that both of them are completely divergent from each other. If a value of a business one says is $5 billion, another fellow will say it's $10 billion. Now, there can't be that big a variation in the cost and the value. Arbitrators use what is called as hot tubbing. For those who don't know, hot tubbing means they don't actually put them in a tub, but they ask both the arbitrators to sit together, resolve the differences, and come forward with one common chain of what they agree on and what they disagree on. And with what they disagree on, the arbitrators decide. So as to bring about a cohesion in what are the areas which I'll tell you why it happens. It happens because there are no chartered accountants on the panel of arbitrators. Chartered accountants are the ones they rely on, and both parties give varying methods of valuing the same asset. Which is why you need, if I may say so, clearly independent and to some extent impartial chartered accountants who give fair valuations. Now, if that happens, I can tell you without any doubt in my mind, the scope of work for every chartered accountant is very significant. It is not. I'll tell you where the problem also lies after this. Now you give a report. How many chartered accountants are willing to withstand cross-examination on that report? Because all your reports are only as good as if it can withstand the cross-examination of a counsel or a lawyer. I find, at least with the chartered accountants I've interacted with, they're willing to give a report, but they're not willing to come as a witness. But internationally, it is not a problem. Internationally, if a chartered accountancy firm gives a report, they will come and also justify the report. Justification of the report and preparation of the report and providing that report itself is a significant practice area. And while I see reports of all kinds, to find reports which are acceptable judicially and which are accepted by arbitrators and which are then relied upon to award a claim to a party in an arbitration requires the chartered accountant to come and give evidence on oath that this is correct. But there is, if I may say so, a significant hesitancy on the part of chartered accountants to actually come forward and do that. But I don't know why. Because possibly you have the best expertise to give that report and to then justify it. And that is where I believe not lawyers, not engineers, but chartered accountants who form that very, very specific genre of people who can actually come and give evidence with respect to, and I've seen this, of course, I've seen a lot of large chartered accountancy firms who come and give evidence. There are partners of firms who come and give evidence. Then there's significant cross-examination. But issues like this, you see, we lawyers are really ill-equipped to actually do. That is, so one is, of course, being an expert, then being an expert witness. There is another area. And that area is actually working with the lawyer for making or quantifying claims. And I'm giving you these, of course, it may sound like I'm giving a discourse on various areas of practice that you can branch out to, but really this is something which as a lawyer I encounter significantly. While I know there are 10 broad heads of claims that I can make in an arbitration, the second I am asked to quantify it, I have to take a step back. How do I quantify something like loss of profits? Suppose there's a construction contract to build a road in Bangalore. The road contract is terminated prematurely, because of which the contractor has suffered losses. The loss is, of course, a loss of profit. How does a lawyer make a determination of what the loss of profit is? I'll tell you how judges have done it. Judges have said, in a very strange way, judges have said that, well, we should take, 10% as loss of profit. And therefore, we will award 10%. We know today that no contractor gets 10% as his profit margin. It's almost impossible. If you look at road contracts, it could be 3%, 4%, because the quantum is so large. In a 1,000 crore project, to say I'll get a 10% margin as profit is absolutely meaningless. Yet you will have arbitrators who will hold and judges who will accept that 10% is a reasonable amount of money and therefore we must award it. No, that is wrong. Because you can't give more money than what a person would have otherwise got. Which is where, according to me, only a chartered accountant can come. The chartered accountant can certainly tell a court or an arbitrator that this is his costing, this is the market value, this is the profit that he can make. And you have scenarios where repeatedly we are unable to utilize the role of a chartered accountant in processes of this kind. And that is where I believe, quite honestly, a significant role can be played by chartered accountants. Now, as I was saying, in quantification of claims, as a lawyer, I can't quantify it. Therefore, how do I quantify? I need to rely on someone who can actually quantify it. Cost accountants, chartered accountants come forward and say, yes, this is the mechanism which we do, and this is how I can justify it. And then I then say, to justify this amount, whether it is 2%, 5% or 10%, to justify it, I will have the chartered accountant to come as a witness in an arbitration. But there comes the biggest roadblock for a lawyer. The chartered accountant will turn around and say, I'll give you a report, but I will not come and give evidence in an arbitration. Now, how do we resolve that? That is something which you must resolve at your end. You must find a way to resolve it, because this is where I honestly believe that, quite apart from your traditional practice of auditing, taxation, there is a significant amount of not merely your skill, but also a demonstration of your abilities as possibly persons who protect the finances of a company to be actually demonstrated. And that is where I honestly believe that you must enlarge, if I may say so, the scope of your practice to cover those areas as well. In 2019, the Arbitration Act was amended. The Arbitration Act was amended and they introduced something called an 8th schedule. The 8th schedule to the Arbitration Act says that chartered accountants who have 10 or more years of practice are eligible to be appointed as arbitrators. I'm sure none of you have seen it, because in 2021 it was the entire 8th schedule was removed because everyone said you can't put in a qualification for who must be appointed as an arbitrator. And therefore, of course, the fact is, I honestly believe you don't need a qualification, you only need a consent. Therefore, if I think a particular person should be an arbitrator, he should be an arbitrator. Now, therefore, you have each of these scenarios where I honestly believe that chartered accountants can play a significant role in arbitration. Now, this is adjudicatory mechanism. Now, let's look at the non-adjudicatory mechanism. The non-adjudicatory mechanism is what we know as mediation. Now, I'm quite certain as chartered accountants, given the fact that you're so close to the business of a client, ultimately business of a client is the money, therefore you are the most closely involved. There must have been any number of scenarios where you have settled disputes for your client. Disputes relating possibly to property, disputes relating to their vendors, disputes relating to so many other issues which a chartered accountant is best equipped. But then what happens is, it is without any formal process. It is more on good faith, a discussion is done, chartered accountants are involved and they settle. But do you know that there is such a significant area of mediation as a practice? And this I'm speaking not as an informal method, but as a very formal method of resolving disputes. which is why I said Arbitration and Conciliation Act started as a settlement mechanism. Conciliation never took off. Arbitration, of course, took off very well in India. Then came the Commercial Courts Act, which is a more recent introduction of the law. The Commercial Courts Act says that you must necessarily have something called pre-institution mediation. Now, pre-institution mediation means that before you can go to court on a commercial dispute, you must go through the process of mediation. But unfortunately, what they also did is, they made it only the states established mediation center to do these mediations, which is, of course, which will evolve over a period of time, because now there's something called a mediation bill, which has been introduced into Parliament. Mediation bill says that no dispute of a civil nature can come to court unless the parties have made an attempt at mediation. Which is why you have in Bangalore and in various parts of India, so many mediation centers which have started. So all these mediation centers now want to play a role in trying to bring about a settlement even before a case goes to court. Of course, if a lawyer does not want the case to settle, it's a different matter. He may not allow it to be settled. But then the intention is that you must find a way to settle it before you go to court. And if you've not done it, then the case will not be entertained itself. Mediation, of course, many feel, what is there in mediation? I'll call one party, I'll speak to the other party, and I'll try and bring about a resolution. But mediation is not as simple. If you ask me, mediation actually is by itself a science. It's a method by which you can find a way of resolving in a very formal fashion. It is not and should never be understood to be something as informal as what we do while we call two parties and try and settle the dispute. There is a set process and for some strange reason that process seems to work. But for that process you have to be trained. And therefore there are so many mediation institutes today in Bangalore, at least I know of two, which actually provide this formal training as mediators and empanel you as mediators to mediate disputes between parties. But again, if I go to the Mediation Institute, or of course I'm not a trained mediator, but when I find out, again there is a very small number of, actually there are a few, but a very small number of chartered accountants who actually get into being trained as mediators. Mediation, of course, the beauty of mediation is there is no real formal process. You don't need evidence, you don't need to hear arguments. You need to find a way of bringing parties on the same page. To do that, I think more than lawyers, you as persons connected with the business are most closely associated and have, according to me, the greatest ability to try and find a resolution. To do that, but you must be trained. You must undergo some formal training to act as a mediator. Today they say, of course, there is no requirement in the law that you must be a chartered accountant with 10 years of practice or 5 years of practice or 20 years, doesn't matter. So long as you go through a process. And the beauty of all of it is, once that process is done and a mediation agreement is signed, under the mediation law, it becomes as effective as a decree of a court. And it can be enforced in court as well. Now that is what the role that, according to me, chartered accountants can play in mediation. And this is an area of practice which I would tell you, without any doubt in my mind, you must explore. This is an area which you must not let go of, because this is an area where you will find the biggest resolution of disputes happening at your end itself. Because you are the ones who will be, and it's not just about being mediators, it is actually also appearing before mediators. I remember, of course, it has its pitfalls. Let me give you an interesting story of a very large dispute in Bangalore which occurred some years ago. There was a family dispute, and the chartered accountant, a very senior chartered accountant, was involved primarily in mediating the dispute. He mediated for over 6 months or 8 months or close to a year, and finally they brought about a resolution. They put it down in an agreement. The agreement also said that he will be the mediator during the process of the time the parties separate, and that he will hold the agreement as well. No one else had a copy of the agreement. Only the mediator will have a copy of the agreement because they wanted it all secret. As things go wrong, it also went wrong. No one wanted to act on the document. One party wanted the document, the other party did not want the document. Now in this whole thing, who got caught? The chartered accountant. Because he was right in the middle. So the chartered accountant became a scapegoat in this entire dispute. This was because of the interesting problem created of being the person who resolved it and also being the person who held the agreement, also being the person who said, I will resolve it in future. And when things went bad, the first person they attacked was a chartered accountant. Which is why I was also telling him, because I appeared for him later in court because there were so many allegations against him. And of course, ultimately it was shown there was nothing wrong in what he did. But what I'm saying is, you could, because of a lack of formal training in mediation, get entwined in this scenario. If you simply resolve, then you must stay outside. If you resolve and you want to be part of actually running the entire settlement process, then you shouldn't be a mediator. Because you see, there has to be some amount of independence that you'll keep from each of the parties. To be the party or to represent the party and also be a mediator creates that conflict, which becomes, according to me at least, if things go well, it settles, there's no problem, no difficulty. But if it doesn't settle, then of course, things can go really south. And that is when, and that is how you must insulate yourself from any claims that anyone can make of wrongdoing on your part. There were these, I can tell you so many different stories of how arbitrations have gone wrong or mediations have gone wrong. But what I want to now tell you, and which I think I should recommend to the association as well, is that the High Court, the Karnataka High Court, has an arbitration center in Bangalore. And I'm quite certain possibly many of you have visited it as well. But the arbitration center has its own rules. Arbitration center has its own panel of arbitrators. The interesting thing is, and you'll be also shocked to note, that the panel has only judges and engineers, not even lawyers, as arbitrators. But because of the changes in the law, what I would definitely recommend to the arbitration to the association, the Chartered Accountants Association, is to make a representation to the High Court to at least include very senior chartered accountants as arbitrators on the panel of arbitrators, so that you'll have that first step of actually getting yourselves introduced into arbitration as an area of practice. And because no one thinks of chartered accountants when they want to appoint an arbitrator, at least in India, but that is quite the scenario world over, that rather see you as experts. But I think this is a great opportunity for you to actually take that first step to try and become arbitrators, and also to then see as to how you can expand your practices to bring about arbitration, acting as experts, acting as claim consultants, and the like, because ultimately, I'll tell you, as lawyers, we will depend on cost accountants and chartered accountants to help value claims. Anyway, I think I've taken a significant amount of time. I just want to conclude with a very famous quotation of Auerbach in his paper, Welcome to Litigation, and why he suggests that you must do alternate dispute resolution mechanisms. I quote, he says, "It is virtually impossible to survive litigation and remain solvent. But it is occasionally possible to endure it and remain sane. As a modern ordeal by torture, litigation excels. It is exorbitantly expensive, agonizingly slow, and exquisitely designed to avoid any resemblance to fairness or justice. Yet, in strange and devious ways, it does settle disputes," he says, "to everyone's dissatisfaction." So thank you very much. It was a pleasure to address all of you. And I do hope to see you as arbitrators and experts in the days to come. Thank you very much.
Thank you, sir. The floor is open for questions if any of our delegates here would have any questions.
I think the question is, what is the procedure for arbitration? Okay, let me, I realize that possibly I should have given you a little more detail on how arbitration works. Now, most arbitrations are contained in arbitration contracts. So you enter into a contract, let us say a construction contract to build a house. The agreement is between the owner and the contractor. An arbitration clause is provided that if there are disputes, you will refer it to either a sole arbitrator or it will be referred to a 3-member tribunal. Disputes will arise. The person who's making a claim, typically it will be the contractor. Contractor will say, I'm entitled to so much money because I did extra work. Or there was a delay on your part and therefore I had to keep all my machinery and equipment here. Therefore there's extra cost. Or you terminated the contract and therefore I have loss of profit. He makes a claim. He does so by a notice. He issues a notice of arbitration and calls upon the other party to pay, failing which he will refer the dispute to arbitration. Then he will nominate an arbitrator. And let us hope he, in this case, nominates Sir as the arbitrator, a senior chartered accountant as the arbitrator. The other party has the opportunity of responding. He can either accept the arbitrator or he will say, I don't want this person as the arbitrator. I am suggesting someone else as the arbitrator. Then there is a scenario where you don't have agreement on the name. In that situation, the law says you must approach the High Court. And the High Court will appoint an arbitrator for the parties because the parties didn't agree. Then a petition is filed in the High Court. High Court appoints, let us say, another chartered accountant as the arbitrator. Then that chartered accountant will call upon both parties to submit what is called a claim statement. So the person who's making a claim is called the claimant. He will submit a claim statement. In his claim statement, he will give the history of the entire story. It will be like a petition which you file in any forum. He will say, this is the loss I've suffered. This is the cost I've incurred. Please award me these amounts of money with interest. Then the respondent, the owner in this case, will get a chance to respond. He will then file his reply and say, no, he's the one who's delayed it. He has not done extra work. All this work was well within the scope of this. And he will file his response. The arbitrator will then say, now there is a dispute between the parties. He will identify what those disputes are. And then he will say, parties should now lead evidence. Evidence now, how do you lead evidence in a case of this kind? Let us say you lead the evidence of an expert to show what is the extent of work done, one. Second, you lead the evidence of a chartered accountant who says this is the loss of profit. Then the other side gets an opportunity. They also lead evidence. And then the arbitrator will hear arguments of both sides and then decide the question as to who is right and who is wrong. He can't, of course, say right and wrong. He'll have to give reasons as to why a particular person is right or a particular person is wrong. And then a determination of that dispute is made. Once that is done, he passes something called an award. That is an arbitral award. After 3 months, if no one challenges it, the arbitral award becomes final. And it becomes like a decree of a court. So once an arbitral award has become final and it is filed in court for execution, a court will execute it, treating it like a decree of a court itself. That is the entire process of arbitration. Of course, one may say it is very similar to how a court works. It's only that the process is alternate to court. It is not as formal. It's very informal. And people sit and discuss face to face. Some formality is there because of the nature of the proceedings, but it is not as formal as a court. But that's what arbitration is all about. Okay, the question is, will there be a clause for mediation in a contract? There are two kinds of mediations. One which is statutory mediation and the other is contractual mediation. Statutory mediations are imposed upon parties and you have to mediate disputes because the law requires. One is the Commercial Courts Act says you must mediate. Therefore, without even a mediation clause, you will mediate. You may, I don't know if you've seen construction contracts. In large construction contracts, before you can go to arbitration, you must go through amicable resolution. So the first requirement is you must go through the process of practical mediation. There are various structures. Something is called a dispute review board or a dispute adjudicatory board. That actually helps mediate the dispute first. If you're dissatisfied with it, then you can go to mediation, arbitration or to a court proceeding. Therefore, there are both processes possible, by a contract where parties agree and through a process of law itself. Sorry.
This is of some interest to me, this particular arbitration. And I was following the Amazon case and one Nissan case. What is the latest position on that? Because first it happened in Singapore, then the ball came to New Delhi, and after that I lost track of who won in that arbitration. And even Nissan also it is lying like that only. So what is the latest we have in it?
Well, that is case specific. Insofar as Amazon, the dispute with Future Group is what you're talking about, I think.
Exactly.
So the arbitration is not fully commenced because what's happened is the arbitrators passed an initial award.
Correct. That was in Singapore.
Yeah.
Singapore, it was in favor of
Amazon.
And it was against
Future, yeah.
But in Delhi, I believe it was something else.
No, the question was, can an interim award passed by the arbitrator enforce or not? That question is still pending consideration. Still pending, yes, yes. Beg your pardon? What's the use of? Oh, yes. Well, you found one case which is an extreme situation. You have millions of cases which get decided without going through this process. It's not that every case this happens. In this case, it happened in this particular fashion because of the size of the litigation and the amount of money involved. There are some legal questions there. Now, of course, we can debate on those legal questions. I don't want to take your time here. But the legal questions are whether the Indian Arbitration Act recognizes a Singapore-based interim award. No, it does, because the single judge of the Delhi High Court held it does. So that is a position today. According to me, it does. There is an interpretation issue on the Arbitration Conciliation Act. So Justice Midha of the Delhi High Court held that an interim award passed by the arbitrators in Singapore are enforceable in India. And that is pending challenge before the division bench.
Hi. You said CS are a little hesitant in being a witness in an arbitration process. Okay. What happens in case if the witness goes wrong? My estimation goes wrong. What are the consequences of that?
Okay, so I was cross-examining a chartered accountant on an issue relating to loss of profits. Cross-examination went on for a long time. And over time it was found that there were some mistakes. So at one point in time, the chartered accountant said, "Are you trying to trap me?" So we said, "No, of course you can go wrong, there's nothing wrong with it. But you can't go so completely wrong also, that you give a completely wrong report." If you ask me, is there a consequence of giving a wrong report? No. Your evidence will have no value. And therefore, the person in whose favor you given evidence will not succeed. But you see, the problem is there are beliefs that it could damage reputation. And the reputational damage may be huge. But reputational damage ultimately depends on what you do. If you give a wrong report and come and seek to justify it, you will bear the consequences of it. But if you give a report which is correct, or which is at least to the farthest extent correct, then it will be accepted. Or, ultimately, you must remember, the role that a valuer plays is quantification. Whether on entitlement is a matter of law and contract. So as a matter of law and contract, entitlement is decided first, quantification is next. So a chartered accountant plays the role of quantifier. So if a person has suffered loss of profit of 1 crore, if a chartered accountant gives a report saying it's 100 crores, it's going to be very easy to knock it off. But if he gives a report saying it's 1.2 crores, then certainly it's a report worthy of acceptance. So it ultimately depends on how you draft it and how you give evidence. And I do expect that he won't lie on oath. That is most crucial. Law. Now that's an interesting question. I've also seen it happen between two Indian parties. But what happens is when there's a foreign party involved and an Indian party involved, foreign party will require, let's say he's from London, he wants London, Indian will say he wants India. So as a neutral place, they choose Singapore. So, and Singapore is closer to India, and Singapore is not as expensive as going to London. So, take into consideration the cost. And Singapore has a robust arbitration center called the Singapore International Arbitration Center, which actually manages the arbitration. They appoint arbitrators and the like. And Singapore courts are very pro-arbitration. So those help in the entire process. And therefore, we've done arbitration in Singapore and Malaysia, Hong Kong. So, there are places where arbitrators are more respected and you get a very professional approach to arbitrations as well. So Singapore is one of those places. Hong Kong, New York, London, France, Paris. There are many others. Of course, we see only this side. Indian parties agree. I don't know why. But I've seen that happen a lot. They want to go there and arbitrate. You can, and the only advantage is if you want to contract out of Indian law. Why you want to do it is a different thing, but if you want to contract out of Indian law, you can contract out of Indian law if you do the arbitration outside India. Although if it's in India, you have to do it in accordance with Indian law. That's one difference, but Indians are very few, not too many. There's always a foreign element involved. It'll be a wholly owned subsidiary in India of an American company or some other company which is arbitrating. That is typically the scenario. It depends on the contract. See, the contract will normally provide a place of arbitration. If there's a place of arbitration, then the courts of that place will have jurisdiction. No, now Justice Nariman has clarified that position, where he said even if there are parties from different jurisdictions, one let's say in Delhi and one in Bangalore, but the place of arbitration let's say is in Bombay, unconnected to the two parties, still the courts of Bombay alone will have jurisdiction. So it is called the situs of arbitration is what will determine the court's jurisdiction. Now you may ask me, is that correct? I doubt it very much, because you see the definition of court in section 2E of the Arbitration Conciliation Act provides for cause of action as a jurisdictional point. But that has been watered down by the Supreme Court by saying that it will be the place where the arbitration is conducted, which will be the jurisdictional seat, not merely of arbitration, but also of courts. So. Then it's Bangalore.
I got arbitrated from Mumbai.
Till.
But future I got arbitrated from Mumbai. But now international agreement says that arbitration has to be only in Bangalore.
Yeah. So there are two things. One is called the venue and the other is called the seat. The venue can change in the sense that arbitrator can say today we'll meet in Bombay, tomorrow we'll meet in Calcutta, the third day we'll meet in Cochin, and the fourth in Bangalore. But for jurisdictional purposes, it will be Bangalore. So when they make the award, finally, it will be at the seat of arbitration. So where you sit, it's like saying I'll sit in Rajajinagar or Basavangudi, doesn't matter. So long as you're in, the seat of arbitration is Bangalore, ultimately when the award is rendered, the award will be at Bangalore. And if you want to challenge the award, it has to be in the courts at Bangalore. That's the difference.
Thank you, sir.
Thank you.
Thank you for enlightening us with various opportunities in the practice of arbitration and mediation, and also for answering our questions patiently. I now request CA Nagraj Siddesh Gaddi to present a memento, which is a live caricature of the speaker as a memento. A huge round of applause for the speaker.